So Article 22 deals specifically with automated decision making. We need to note that not only Article 22, but all of GDPR applies to automated decision making. And in fact, all of GDPR applies to any kind of AI system. There is an overlap, not just in Article 22, but in general, between GDPR and the EU AI Act. There's an overlap in general between privacy law and the emerging law and norms of artificial intelligence, because artificial intelligence runs on data. And some of the data it runs on is data that would be considered PII, personally identifiable information, about an individual: a name, an address, a banking number, a credit card number, a government ID number, all of those sorts of things that can identify a specific individual, anything that can identify a specific individual. So we're not going to go through the whole GDPR, but we do want to just talk about a few places that are going to be important, and again, in which there's some real specific overlap with the EU AI Act. So one of these is in the requirement for conducting impact assessments. We're going to talk about impact assessments throughout this semester in AI law and in a little more detail a little later in the semester. But this is, again, a common theme from privacy compliance that has been adapted into AI compliance, and really from privacy compliance adapted from other areas of general compliance. And a DPIA, Data Privacy Impact Assessment, or PIA, Privacy Impact Assessment, is just a way of making a kind of formal review of the impact of a certain kind of activity on privacy, right? On what kind of data we're collecting, how we're using it, and those sorts of things. And Article 35 of the GDPR requires, in certain cases, a DPIA to be conducted. In particular, when there's data processing that's likely to result in a high risk to the rights and freedoms of natural persons. And remember, privacy is a right under EU law for a natural person. So if there's going to be a high risk, a high impact on privacy, then you've got to conduct a DPIA. A DPIA is always going to be required if Article 22 is triggered. So we should note here, as you go through that analysis of Article 22, you decide, okay, Article 22 is triggered, right? Now I've got to make sure that I've got the contractual basis, or I've got consent. So let's say I've got consent. Now I've got to make sure I have all these back-end rights of human intervention and a right to contest. I also, before implementing this system, need to do a DPIA. So I need to have a formal process, I need to document this, and I need to have this available for the regulators. We're going to talk about this again a little bit later in the semester, but under the EU AI Act, there's a similar kind of process through which a provider of an AI system, which is the entity that is, creating the model, creating the system, has to do an impact assessment, and actually has to, it's called a conformity assessment under the EU AI Act. And there are requirements within the Act for what that has to include, and that's got to be kept by that provider and be made available to the regulators. Now, another important place that GDPR is going to apply regarding automated data processing and regarding AI in general is with pseudonymization. And the concept here, right, we've talked about PII, personally identifiable information, which any kind of data that identifies a natural person. If data is anonymous, it is not PII. It doesn't identify any individual person. So take a transaction ledger. It might have name, it might have address, it might have card number, it might have date, it might have the price, and let's say the item number, right? So let's say we took this ledger and we stripped out name, address, and card number. All we had was the item number, the date, and the price. That could be very useful information. and all we fed into a system, or all the data we were processing were these three things, we have anonymized data, right? All of the PII has been stripped out. In that case, privacy law, GDPR is not triggered. Of course, if this data is still included, GDPR is triggered. Now let's say instead, right, we have our name, our item, we have our name, we have the card number, we have the date, we have the address, right? We have the price. Say these things weren't stripped out, the name and so on, but they were just blurred. And through an electronic technique, maybe they were encrypted, right? So those pieces are encrypted, the other pieces are known, and all of it's being processed. So there we've got something called pseudonymization. It's not really anonymous, but because of some technique that's applied to it, it's at least at some point in time not accessible. Now, pseudonymous data, GDPR does apply, but if it's not accessible, then it's not really data that we have to worry about. But if it is accessible, if it is data in which what has been anonymized can be unmasked and disclosed, then we have it's not really anonymous data. We have all the requirements of GDPR. So in our case of where the PII has been encrypted, if a third party has the ability to decrypt it, if they have a decryption key, for example, well, then we really don't have data that is anonymized. It's pseudonymous data that a third party can access, and we've got to make sure all the requirements of GDPR are met. So anytime that you're thinking that you're anonymizing data, but there's some way to reconstruct it, and therefore it's pseudonymous data, we've got to be really careful. And if we're going to claim that the requirements of GDPR don't apply, we've really got to be able to demonstrate that you can't reconstruct the PII from the data that is available. So in our example of data that has been encrypted, if you're using true, kind of commercial grade encryption, it's pretty unlikely that a third party is going to be able to unmask that unless they literally have a decryption key. You simply can't, through raw computing power in any reasonable amount of time, break commercial grade encryption. But there are other techniques that could be used to pseudonymize, to try and obscure. And the basic test that the GDPR uses is a reasonableness kind of test. What are the means that are reasonably likely to be used to try and re-identify that information, including costs and amount of time and existing technology? So commercial grade, off-the-shelf encryption, we're literally talking a lifetime to try and decrypt it with huge amounts of computing power. Not reasonably likely to happen, right? There are other techniques that would be easier and much more reasonably likely for someone to find out the information. With AI, the really interesting question is about training data. As AI, especially large AI models, are, as we know, are trained on large data sets, and those large data sets often include PII. If you take a base model like a large language model like ChatGPT, it's trained on the corpus of the internet, essentially, and it's going to include a lot of PII. It's going to include, say, your name on a paper that you've written that is accessible on the internet. That's PII. And what we know about how systems like that work is that the original data itself is not stored in the system. So let's just take my name. I'm just going to put my initials here, but let's say that's my whole name. It's on a paper that I've written, right? And maybe even my work address is on there. This piece of information is among that which has gone in to train this LLM. So it's not the case that this PDF file is sitting there in storage on the LLM, of course. What happens is that the pieces of this are broken into tokens. It's tokenized, right? Those tokens are weighting the algorithms that are in the LLM. So what's in the LLM are simply mathematical models, algorithms. So could you actually extract from what's in the LLM the PII, my name and my address that's on this paper that is published somewhere? Quite possibly, interestingly enough. And there's a lot of research that's been done on this. It depends on the system. It depends on, what the weights are. But even though it's all tokenized and it's only predictive and the whole thing isn't literally stored in the LLM, with not necessarily terribly sophisticated but careful prompt engineering, it is possible in some cases to extract PII from something like a large language model. All of which is to say, you might think that the data is anonymized or pseudonymized because it's broken into tokens and there's just algorithmic weights. But it might be possible, and it might even be reasonably possible, to reassemble it. So the best practice really is to say, when you're thinking about your AI training, you want to make sure that if there's PII involved, you're complying with privacy laws. It's entirely unclear what that means for some of the existing products that are out there, particularly some of the existing large language models. Nobody went out and got privacy consents, just like nobody went out and got copyright consents. Nobody went out and got privacy consents and notices when they trained ChatGPT on the corpus of the internet. What does that mean? I don't think anybody's entirely sure. It's not to suggest that you can't use the ChatGPT engine as a basis for some kind of, commercial, like a chatbot or something like that. You just do need to be aware there's a privacy risk, and it may very well not be fully GDPR compliant. Speaking of using something like an off-the-shelf AI model, the GDPR and other comprehensive privacy laws place obligations on a data controller for some of the actions of third-party data processors. The basic model under GDPR is you have a controller who is responsible for determining the way data is going to be used, and then you have a processor who is actually doing the processing, collecting and performing some actions on the data. The controller and processor may be the same entity, but they may not be the same entity, which means that if you are using any third-party vendors, either to collect or to process personally identifiable information, then you as the controller have obligations with respect to that processor. And your obligations primarily are to know what kind of information they're processing, to know what their policies and practices are, to have contractual terms and to have oversight over what they're doing. And all of this is going to apply to AI activity when the AI activity might implicate the GDPR, either through automated decision-making and or through other aspects of processing of PII. So as we've been discussing here, that's pretty broad. A lot of AI applications are going to have GDPR implications. So that means if your client, your company, is using third-party vendors, either using their AI models and integrating them into products or services you're offering, or simply using their products on your employees' data or your customers' data or whatever it might be, then you have GDPR, almost certainly have GDPR obligations with respect to them to know what they're doing and to have contractual terms and have oversight over what they're doing. Another and related area to be aware of is cross-border data flows. The GDPR puts obligations on anyone who might be processing the personally identifiable information of European data subjects. In other words, European individuals who are protected by the GDPR. And it puts obligations on whether data is crossing national boundaries. In other words, crossing outside of the national and EU boundary, right? Crossing outside of the EU to somewhere else. And in particular, I'm going to try and draw the United States, which is not going to be very good. And I'm going to try and draw Europe over here, which is not very good, right? So if data is being processed and flowing between the United States and Europe, then there are going to be GDPR obligations about whether, in fact, the data can flow that way. So under GDPR, it is contrary to, violates the regulation to let data flow across borders unless one of these conditions is met. So the one that I think was meant to really be the most significant is an adequacy determination. So an adequacy determination means that the EU has determined that in general, a country's data protection laws and policies and practices are basically equivalent to the protections offered by the GDPR. So you could effectively trust that a European data subject's data that is flowing across that border is going to be treated in roughly the same way as the GDPR. This really hasn't turned out to be that broad because there are very few of these adequacy determinations that have been made. And if you've taken information privacy, you know that this has been a fraught relationship with the United States. There have been several efforts at this that have been challenged, in which adequacy determinations made by the EU have been overturned by the European Court of Justice. And there is currently an adequacy determination that is again being challenged. So this is a possibility, but it's relatively few countries and subject to challenge. There are some other kinds of mechanisms in which an individual entity can adopt corporate rules or use contractual clauses or go through a certification mechanism in order to get approval for that entity. And then there's also the possibility of consent, although having consent on an individual basis to cross-border data flows is going to be quite cumbersome. So what generally tends to happen, and what has happened in the US, is you hope you have an adequacy determination, and for those periods where we have not had an adequacy determination, companies have had to rely on, some combination of the corporate rules or clauses or a certification kind of mechanism, or really kind of roll the dice and hope that certain kinds of data flows didn't get enforced against. Now, with AI, this is really going to become significant, again, especially because of AI training. You need to know where your training data is coming from and where it's going when training is being done. And this might seem simple, but if you think about a large model and the huge corpus of data that might be required for training, and the fact that a lot of this, the compute power, is likely to not be in-house because it's an enormous amount of compute power, but it's likely to be in the cloud through Amazon Web Services or through some other cloud provider. That means you're using a third party. You've got to know where that data is flowing, and is it flowing into and out of server farms, places where there are adequacy determinations, and or if it's not, do you have some of these other backstops with that provider? It's a really kind of difficult challenge to ensure that you're complying with cross-border data flows if, in fact, you're training a large model on a large amount of data. The last general GDPR principle that I want to mention is incident reporting. So under GDPR, there is an obligation to report a security breach. In my cybersecurity and data privacy classes, I often say, you can have security without privacy, but you can't have privacy without security. Why is that? Well, you can have perfect security if you simply erase all the data that you have. Nobody can steal it if you don't have it. That's perfect security in a sense. And you might think, okay, that's perfect privacy too, right? Nobody can get access to the data. Except that, remember, privacy under GDPR gives rights to the data subject, not only that their PII will not be improperly disclosed, but also that they, the data subject, will be able to know what information you have collected, to retrieve that information from you, to be able to correct that information. There are a lot more rights that go with privacy than simply security. So you really can't have you can have security without privacy, just erase all the data. But you can't have privacy without security. If the data is not secure, it will be disclosed to a third party, and then you won't have privacy. So there are this overlap shows up in one place. It shows up is in these these breach reporting requirements within GDPR and other comprehensive laws, like at the state level. So just notice that this is a very tight turnaround to make a report to a data protection authority, and that is the national authority at the state level, the nation level, that is responsible for privacy. For the individual data subject, it's kind of a reasonableness, undue delay kind of standard, but very tight turnaround for the DPA. And the difficulty, and we're really just beginning to think about this on the cybersecurity side, is how easy it is or isn't to exfiltrate data from an AI system. That is a similar kind of problem that we were talking about with pseudonymized data. What can be reconstructed from what the training data was after it was tokenized, right? What can be reconstructed and pulled out of the system? And that's going to be really difficult. And then how can an AI system be used to do data breaches and data theft? All of these things are going to complicate cybersecurity. They already are complicating cybersecurity. And all of that is going to complicate breach reporting obligations, whether it's under GDPR and other comprehensive laws, or in the US, whether it's under state data breach reporting laws. So I hope you see Article 22 is really important for automated data processing. The GDPR as a whole applies and is important. Privacy law as a whole applies and is important as to any kind of AI application. And there are a number of places that we've looked at here in which specific provisions of GDPR and other comprehensive privacy laws are going to raise particular challenges for AI applications.